Good morning, Mr. Johnson, you can hear us, right? And Attorney Dunn?
Yes.
Yes, I can hear you.
Oh, perfect. Okay, so we're gonna get started with your rescission hearing. Good morning, I'm Theo Meister, hearing examiner for the Board of Pardons and Paroles. Can the board members today please state your names for the record?
Jennifer Zaccanini, Deborah Smith Palmieri, Hannah Member Barry.
This is a rescission hearing concerning Johnson Taavon, number 359437. Today is December 5th, 2024. This hearing is being conducted at MacDougall Walker Correctional Institution and the BOPP Central Office. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your name and inmate number for the record, sir?
Taavon Johnson, 359437.
We have counsel here today. Can you please identify yourself for the record?
Yes, Attorney Patrick Dunn from Inmates Legal Assistance Program.
This is a rescission hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. If I find you violated one or more conditions of your release, the board will consider whether or not your release should be rescinded. The decision made by the board today will be made final. This is an administrative hearing. The rules limiting the type of evidence admissible in a criminal trial do not apply in a parole rescission hearing. Disputed charges will be resolved by the preponderance of the evidence. The preponderance of the evidence means evidence that taken as a whole is more credible and convincing than the evidence offered in opposition to it. If at any time during the hearing you have a question about the procedure, feel free to ask me about it. At this hearing, you have certain rights, which I will now review with you. Did you receive the notice of this hearing?
Yes, ma'am.
Okay. Did you receive a packet of information which includes the rescission notice and information supporting the charges against you?
Yes.
You have the right to be represented by an attorney at this hearing. You have Attorney Dunn here today representing you. You have a right to submit relevant documentary evidence. Do you have any relevant documentary evidence to submit?
Not at this time. Not at this time.
Okay.
I am going to ask the gentleman to make a statement later, but for now, no, we have nothing.
Okay. At this hearing, you have a right to call voluntary witnesses and cross-examine adverse witnesses. Do you have any witnesses to testify today?
None other than my client.
Okay. So are you prepared to proceed with the hearing at this time?
Yes.
So I will review each charge and inform you of the information underlying the charge. I will then ask you to admit or deny each charge and will give you an opportunity to respond to the charge. If you choose to make no reply to the charge, the hearing shall proceed and my decision will be made on the basis of the information available. At the conclusion of the fact-finding portion of the hearing, I will inform you my findings. The hearing will then be turned over to the board to consider your suitability for re-release. The testimony at today's hearing will be taken under oath. So, Mr. Johnson, can you please raise your right hand? You solemnly swear or solemnly affirm, as the case may be, that the evidence you shall give during this case shall be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury?
Yes.
So I'm going to read charge 1 under significant adverse information. On 8/8/2024, the parole board reviewed Mr. Johnson during a board review hearing and re-paroled him for 11/8/2024. After Mr. Johnson's board review, he received the following Class A disciplinary reports. 10/6/24, interfering with safety and security for flooded tier. 10/6/2024, interfering with safety and security through trash and feces onto the tier. 10/4/2024, interfering with safety and security, created unsafe situations for self and staff. 10/3/2024, flagrant disobedience, challenge authority and caused interruption of daily facility operations. 9/8/2024, intoxication, tested positive for THC, and 9/8/2024, contraband class A, drug paraphernalia discovered in offender's property. So would you like to offer, or would you like to respond to that charge, sir?
For me?
Yes.
Yes, I take full responsibility for everything, yes. And I would like to present, a letter, if you don't mind.
Go ahead.
First and foremost, I want to thank the board for letting me present myself in this rescission hearing. As I get into this letter, I'm gonna be straightforward. I know why I'm here today. As far as I say, I'm not here to make any excuses. I wasn't perfect at all. As far as my misconduct, I'm aware of my wrongdoings after being granted parole. I'm taking full responsibility of my actions. I was wrong. It was very immature of me. I was going through a very difficult time around that span of me catching tickets, losing my grandfather. I was hurt, broken, crushed, sitting inside a cell on 24-hour lockdown, not being able to come to peace within myself. I was not able to talk to my family or even attend a funeral to see my grandfather get buried for the last time in my life. Honestly, I lost it to the point I even lost myself for the moment because I caught myself doing unnecessary behavior I normally don't do. I was in a hostile environment and segregation ain't made things better, it made it worse. I needed help, comfort, and assistance. I asked countless staff members to speak to mental health, which was never granted to me, so I caught multiple tickets to seek attention to get my voice heard, which made matters worse. That's why I'm sitting here today in front of the board. I'm currently still learning and growing. These tickets I caught doesn't define who I really am as a person. I just made a few bad decisions that I fully regret and wish I could have went about it a different way. I can't take it back what happened. Only thing I could do is learn from my mistakes and make better decisions, grow from it and move on as life goes on. I haven't received a ticket in 2 months or gotten into any trouble. I've been staying to myself and under the radar so I can get back to my family and kids and live a productive life. I have a lot of great opportunities once I get back into society for as a mandatory job and programs to make myself a better person. What I learned from this situation is not letting my emotions get the best of me, no matter what the situation or problem is. I just have to face my matters head on and take a deep breath and not get too unmoral. I learned my lesson. My freedom is way too important to be inside jail, fooling around. There is no life and help inside jail. I need my life back. I want to apologize to myself, my family, and to the board. I hope the panel could take into consideration and grant me parole to rejoin society. I'm a month past my date. I've been DR free for 2 months. The holidays coming up. I would love to spend time with my 2 adorable kids. That would be the best gift to them. I would really appreciate it. Once again, thank you for letting me read this letter. Thanks, Dave.
Thank you. So would
Thank
you
you,
like
sir.
to offer do you deny these charges? Is that a full admittance or a partial admittance?
Well, I take full responsibility, yes.
So what I'm gonna do next is I'm gonna announce my findings. So I do make a finding of violation on that charge. One, condition significant adverse information based on admission of guilt, as well as evidence and testimony provided, which I find more credible than anything offered in opposition to it. So that includes the fact finding portion of this hearing. Should you be re-paroled, do you have a plan, a release plan? Such
Yes.
as employment, where you'd like to live? Can you please explain that?
I have employment in Stanford, which I was working before I got incarcerated. My people's study in contact with my manager and stuff. So as soon as I get released, I still got a job to go to. And like far as like getting released, like I'm just trying to be a better person. Like for me, myself, I got 2 beautiful kids. I got love, support out there. So yeah.
So do you have a
Gentlemen.
sponsor, or do you need
Yes.
housing?
The gentleman's mother will sponsor him. She's been a resource for him and she will continue to be a resource for him. Is that correct, sir?
Yes.
Can I have her sponsor information? So I need her name, phone number, and address.
Cynthia Doherty, 203-534-9266. And the address is 546 Ogden Street, Bridgeport, Connecticut.
546, what was that?
Ogden Street, Bridgeport, Connecticut.
How do you spell that?
OGDEN, Ogden Street.
Yeah, it's the same spot.
Right, and where did you plan to work at?
In Stanford, Rising Brewing.
What is?
Verizon.
Rising Brewing on 424 Fairfield
I
Ave.
say what? Is it coffee shop?
Rising Brewing, like Rising
Brewing.
Brewing.
Brewing. It says brewing here, brewing.
Is that full or part-time?
Pardon me?
Is that full-time or a part-time position?
Oh, part-time, yeah. I was currently going to Nets 2 in Bridgeport for my CDLs, but I got incarcerated, so yeah, I'm trying to plan on finishing that when I get back onto society.
Right, so I will note on the record, Ms. Johnson's re-parole date was for 11/8/2024. His end of special parole date is 1/28/2031. So I'm gonna now turn this hearing over to the panel chair.
Thank you. Mr. Johnson, how old are your kids now?
My daughter is 15, my son is 10.
15 and 10. Do you like being there? And that's a serious question. Do you like being where you are?
No, not at all.
Because what I see in your file is a whole lot of self-sabotage. So the tickets you got from the last time you were in, your full sentence cost you your discretionary parole, right? Then you go out on community release and you sabotage that, mess that up, and you come back. And while you're on special parole, you've gotten, let's see, several violations, and now we give you a new date, and that's not good enough either. It's like you're ruining your chances at every opportunity you get, and I don't understand it. Like, these tickets are ridiculous. When you're waiting to go back out to your children, to your job, to school, it's just so unnecessary. I don't understand it. You're not a child throwing a tantrum.
I understand.
So what is the problem?
I was going through a very difficult time. It was my grandfather's house. I lost control of myself. And I take
So,
full
I'm a little older than you, so I'm going to give you a little advice. There will always be an excuse or a reason to make poor decisions and to screw up and do the wrong thing. So you have to focus on trying to find ways to do the right thing always, regardless of what's going on. Those are called coping skills. You took good programs. Did you gain any tools?
Yes, I did.
So why didn't you utilize those tools in tough times?
I just lost myself, losing my grandfather. I needed peace within myself. I couldn't even talk to my family members at that time. So I'm learning from it, though. I'm still learning.
It's just unacceptable. It really is. I mean, we have staff that goes to work there every day and do the best they can. They don't need people throwing feces at them, telling them to F off. I mean, it just doesn't make sense. Some of the things you were doing, you're using drugs. What did you think was going to happen? We were just going to ignore all that and open the doors for you to go back out and make some more poor choices?
No.
Were you thinking about the consequences of your actions at all?
No.
You do understand we can rescind your parole altogether and you can stay there until January 28th of 2031. Do you know that?
I would ask the board to consider, though, that the gentleman did take responsibility for what happened. He pled guilty to all the tickets.
Yeah, I
He
appreciate
made
that.
mistakes, and he's not fighting them. He admits he made mistakes.
I just want him to understand what the consequences are. I want us all to understand what could happen, because maybe you didn't know when you were getting these tickets that you could lose your parole date. I just want to make sure you know how it works legally. Okay. And I do appreciate you taking responsibility, but at some point those words lose their effect. Mm-hmm. When you keep saying it over and over and over again and continue to make poor choices, it's like the boy who cried wolf. Eventually no one's going to believe you anymore. And I feel bad for your mother and your children, because they've been there to support you. And it has to be heartbreaking for them. So if you can't do it for yourself, think about the other people. Like, your kids need a father.
Absolutely. It's not only affecting me, it's affecting them. Yeah, you're right.
Yeah. It's very clear. It was a period, and you're right. It's all within a period. You've been disciplinary report free for a couple months now. So hopefully you've gotten it all out of your system and you can go back out there and be successful. But parole, DOC, you know, the parole community services, we're not going to tolerate this type of behavior. I just want you to know that. Ms. Palmieri?
Thank you, Madam Chair. So the chair pretty much went through, I think, what all of us are thinking in terms of your conduct since the last hearing. So tell me what your plan is going forward. You have a job, you can live with your mother, but what's the job for taking care of your mental health? Have you thought about that? What is your plan for that?
Going to see a psychiatrist because I've been through a lot. I'm like crushed. I lost my little brother to gun violence, so I'm just kind of crushed. Like I lost myself. Like I'm just trying to get my life back on track. I've been through a lot in my life. So I kind of like got a little kind of anger problem. I'm trying to see like anger management programs, stuff like that, to make myself a better person.
And I don't think there's one of us that would disagree with that, and the need to really seek out grief counseling. And I always say this, you need to advocate for yourself. You know, acting out is childish. It's immature. It's what you would expect your 15-year-old to be doing, you know, making poor decisions. So being able to look for services for yourself, that sounds to me like that's your best course of action in terms of being able to maintain yourself in the community, working and going to school, because you'll never finish NETs if you're in and out of incarceration.
Absolutely.
Thank you, Mr. Johnson. I've nothing.
Thank you. And I will note for the record, they did increase his mental health score. Ms. Berry?
Thank you, Madam Chair. So, Mr. Johnson, from the time that you received your last disciplinary infraction up until today, you were talking about you lost your grandfather. When did that happen?
October 1st.
Of this year?
Yes.
My condolences. And you said that you were reaching out continuously to DOC for additional help.
Yeah, so around that time when I was reaching out to speak to mental health, it was on a weekend, so I wasn't being able to talk to nobody. So I kind of just, I was in
And so
setting.
have you been able to since talk to someone?
Yes, I talked to mental health. No, I got mental health practitioner. I talked to her yesterday.
And when was your first appointment? When was your first meeting with that person?
When I got out of SEG on October 9th.
On October 9th.
Yes. And I take medication. I was diagnosed with PTSD.
Yeah, I wasn't really asking about that. I just wanted to make sure, because you said in your opening statement that you were seeking help and they weren't helping you. So I just wanted to make sure that you address those things, because you know, even there were still
Yeah, sorry that.
It's okay. It's okay. You were still misbehaving a little bit even after that. So I just wanted to make sure that you were addressing that the needs that you were expressing to us had been met. And so you have better skills now to cope. I heard you talking about your brother, losing your brother as well. Tell me, like the chair said, you know, unfortunately, we all lose people. It's just a part of life, and you do have to have some coping skills. Tell us what you intend to do with the treatment that you've received so far to address your coping skills and your grief.
Talk to my family members, surround myself around positive people, stuff like that. Ain't really no helping. I was trying to do program, but I'm not on a sentence, so it's like, and once you catch tickets here, you really can't do no program. So
Right. Well, they had anger management as one of your conditions when you were out in the community, but I
never filed. I was going to a program on Bond Street, but my parole never told me to go to anger management. I never followed up on that.
It is one of your conditions, and I'm just you have to stay out there long enough to actually get the help that you need, and we can't address those things if you are not compliant. And that's what our issue is here today. If you cannot demonstrate to us that you can be compliant in the facility, it's very difficult for us to believe that you will be compliant with the officer out in the community. Our number one priority is making sure that we release those individuals who we believe will return to the community and be law-abiding, contributing members. But from your behavior there in the facility, I don't think that you've really proven that just yet. All right, I'm all set. Thank you, Madam Chair.
Thank you. Attorney Dunn, is there anything else you wanted to say before we deliberate?
Yes, I've been in touch with the gentleman. We've discussed things. His remorse is genuine. I believe that this is somebody who really does want to turn his life around. And as the board knows, DOC does the best they can, but you can't get the assistance you need when you need it sometimes. I believe he was going through a very difficult emotional, psychological period. And sometimes the only way to get the attention of mental health is to act out. It's not excused. He took responsibility for his actions, but I believe this board gives him the opportunity to go home. He has a chance to do something with his life still. He's young enough. His children need him there. He has resources with his family, and it looks like he understands that anger management, whatever programs are requested or required by the board, I think he's going to do them because he does not want to be back there. He's been in prison before. It's not doing anything to help him. He knows now he's got to help himself, or he's going to be sitting here talking to the board again a year, 2, 3, 4 years from now. Nothing's going to change unless he changes it. The only opportunity he has to do that is if he's out.
I haven't thought about it.
Okay. Thank you. All right, the panel's going to deliberate this time. You can listen to our deliberation and we'll come back to you shortly with our decision. Okay, so, I'm happy to hear the explanations from Mr. Johnson. Of course, understand the loss of a loved one is difficult, but, we have to find ways to deal with it. And the fact is the ticket started before.
I was about to say the same thing.
So, and there's been issues with compliance all along. So obviously there, in my opinion, there has to be some consequences for his actions. I would suggest, these are just my thoughts, a month for each ticket. That's what the punishment is with DOC, a 6-month sanction. He goes back out there. He's with us till 2031. We're not going to keep him that long. We don't want to keep young people in prison. So he's going to have to go back out there and try again. But what are your thoughts, Ms. Palmer?
So I was on the same page as you, Madam Chair, in terms of a month for each ticket. In looking back, I do want to point out that he received a 6-month sanction for the last violation that he's now here before us. And before that, there was a 3-month sanction. So it's 3, 6. So I did look at it and say, well, maybe that needs to be increased to 9 months. But I do feel that with the fact that there has not been a ticket since October 6th, that he is participating in some mental health services now and appreciates the need for that in the community. I do see that as a plus. And something that might mitigate increasing the sanction to, I was looking at 9 months, but keeping it at 6.
Okay, Ms. Barrett?
I would argue that Mr. Johnson has demonstrated that he can go a few months without disciplinary infractions. From the last, one of the disciplinary infractions that's not a Class A was in June, and then he got another one in September, which his grandfather was still alive, and then he started accumulating a number of other tickets. But, I see that he has the ability to demonstrate that. So I'm not really leaning very heavily on his ability to stay out of trouble. I do agree with now that he's in treatment, hopefully that really is benefiting his decision making. And I would advocate for him to continue that treatment for as long as possible to ensure that he can return to the community and be successful. So I too would do a 9-month sanction.
9 months.
Yes.
Were you okay with 6 months?
I was fine with 6 months based on that he has gone for 2 months now since October 6th with no tickets. I just was pointing out it was 3 months, 6 months, and do we want to mitigate now that his mental health score has increased and he's in treatment? Does that for me that could mitigate that extra 3 months?
Well, I also think 6 months for him right now is a long time to stay out of trouble. If he gets more tickets, he's coming back to us again,
Yeah.
and he's gonna lose his date. So I think 6 months is a sufficient amount of time for him to prove himself, but, you
Yeah,
know,
and also remain on the regimen that
Yeah.
that's my thing. I'm just like, I
Right.
think that he really has sabotaged himself so many times with the violations and the
Right.
tickets he needs to get the help that he needs
Yeah.
so that when he is out there.
okay,
That's why I said the 9 months, but I'm not opposed to.
Okay.
Exactly.
all right.
But my earrings and.
This is a gift.
It really is.
I hope he appreciates. In the matter of Taavon Johnson, inmate number 359437, I'll make a motion to rescind special parole and re-parole with a 6-month sanction from the original parole date of 11/8/2024, re-parole on May 8th, 2024. With the
25.
I'm sorry, I'm going backwards. May 8th, 2025, with the following conditions. No contact with your victim, initials KC, no consumption of alcoholic beverages, anger management program in the community, halfway house placement if it's needed. I understand you have a sponsor, but just in case, and a mental health evaluation and treatment if it's deemed necessary. Is there anything further? Nope. Is there a second to the motion?
You know, there was I'm sorry.
Sorry.
There was an original condition of no alcohol.
Yeah,
I said that.
Oh, you did. I
I did.
apologize. Okay.
All in favor?
Aye.
Aye. Okay, do we understand,
Yes.
Mr. Johnson?
Yes.
Okay, keep working on yourself. Please don't come back. We wish you the best. Thank you, Attorney Dunn.
Thank you.
This concludes the hearing. Mr. Johnson, 359437. You guys are all set. Thank you.
Thank you.
I can write that one out.
Ask them to mute.
No,
So did
I'm
you get-
warning.
you muted?
I muted Robinson. You're muted, but we're not starting till 10:30. Thank you.
Good morning, officer. Can you just unmute on your tablet? If you press the microphone button.
Is it on mute?
Yes,
Can you hear me?
Yeah,
Can you hear me?
thank you.
Okay. Who do you want first?
We only have Kenny Nieves.
Say that again.
We only have Mr. Kenny Nieves. That's the only person we have for this afternoon.
Yeah, Vince?
Good morning. What is your name, sir?
Good morning. My name is Kenny Nieves.
Yeah, that's okay.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This morning, we have board members.
Jennifer Zaccanini.
Deborah Smith Palmieri.
Panel Member Barry.
This is a rescission hearing concerning Kenny Nieves 339-506. Today is December 5th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Carl Robinson Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Please state your full name and inmate number for the record.
Kenny Nieves, 339-506.
Counsel, please introduce yourself for the record.
My name is Attorney Bryan Canning on behalf of Mr. Nieves.
This is a rescission hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. If I find that you have violated one or more of the conditions of your release, the board will consider whether or not your release should be rescinded. The decision made by the board today will be final. This is an administrative hearing. The rules limiting the type of evidence admissible in a criminal trial do not apply in a parole rescission hearing. Disputed charges will be resolved by the preponderance of evidence. The preponderance of evidence means evidence that, taken as a whole, is more credible and convincing than the evidence offered in opposition to it. If at any time during this hearing you have a question about the procedure, feel free to ask me about it. At this hearing, you have certain rights which I now will review with you. Did you receive written notice of this hearing?
Yes.
Yes.
Did you receive a packet of information which includes the rescission notice and the information supporting the charges against you?
Yes.
You have a right to be represented by an attorney at this hearing. You have Attorney Canning here today representing you. You have a right to submit relevant documentary evidence, which I have reviewed and received this morning from your attorney. Attorney Canning, do you have any further relevant documentary evidence you would like to submit today?
No, that's it.
Thank you. At this hearing, you have the right to call voluntary witnesses and to cross-examine adverse witnesses. Do you have any witness to testify today?
No.
Thank you. Are you prepared to proceed with this hearing at this time?
Yes, we are.
I will review each charge and inform you of the information underlying the charge. I will ask your attorney to admit or deny each charge and give your attorney an opportunity to respond to the charge. If your attorney chooses to make no reply to the charge, the hearing shall proceed and my decision will be made based off of the basis of the information available. At the conclusion of the fact-finding portion of the hearing, I will inform you of my findings. The hearing will then be turned over to the board to consider your suitability for re-release. The testimony in today's hearing will be taken under oath. Mr. Nieves, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or penalty of perjury?
Yes.
Thank you.
Two of them.
On charge 1, significant adverse information. On May 23rd, 2024, Ms. Nieves' revocation board review hearing was held. The board voted to re-parole Mr. Nieves on December 9th, 2024. On October 5th, 2024, the victim in this case contacted the Board of Pardons and Paroles to inform the panel that Mr. Nieves has continued to contact her despite there being a protective order in place. The victim expressed that she has blocked the jail number. However, Mr. Nieves has reached out to her through a friend who then conducts a three-way phone call. She continued to state on October 3rd, 2024, Kenny did this multiple times with my son's iPad. I was able to record a video of him doing so. Due to Mr. Nieves' 12/9/2024 re-parole date approaching, she's very worried for the safety and well-being of herself and their 2-year-old son that they share. It's important to note Mr. Nieves is subject of a protective order, naming the victim as a protected party. The protective order was issued on April 9th, 2024, with an expiration date of April 9th, 2025. The protective order also states an impartial party to be used to facilitate and coordinate contact for parenting time. Mr. Nieves received 3 Class A disciplinary reports on October 9, 2024 for the following. Blatant disobedience. A phone review was conducted on Mr. Nieves. It was discovered that Mr. Nieves was contacting the victim of his crime. Security tampering. A phone review was conducted on Mr. Nieves. It was discovered that Mr. Nieves utilized a 3-way phone call to contact the victim of his crime on October 3rd, 2024 at 7 p.m. Flagrant disobedience. Mr. Nieves was processed into RHU and escorted to cell 6B. Mr. Nieves stated that he was not going into that cell with another inmate. He repeatedly stated that he did not want to be in a cell with another inmate and was escorted to RHU cell 1A. Attorney Canning, would you like to respond to the charges, partial minutes, full minutes, or denial?
Yeah, I'd like to respond to them. So basically what happened is a 3-way call down at the facility. Mr. Nieves pled out the disciplinary reports. They have the recording, basically where he said, you know, hey, how's Luca doing? Or excuse me, how's my son doing? He's trying to be a good father, you know, keep updates with his son. And that's the evidence that we submitted. It's text messages from the victim to his uncle saying, if Kenny needs updates for our son, please reach out at this number. That's what he was doing here. As you can see, it was following the last hearing that was held on May 23rd. All the text messages are from 24th, 25th, 26th, providing him with a number to receive updates regarding their son together. Mr. Nieves understands that this is against institutional policy as far as 3-way calling, took responsibility, pled out to all the DRs. He did receive 10 days in segregation, loss of rec, loss of commissary, loss of visits, tablet. He is still currently dealing with some of those sanctions, and he is remorseful, and I do believe that. He realizes he has made a mistake, can't be doing that moving forward, and he does take responsibility for his actions and has admitted to the disciplinary reports and as such the adverse information.
Thank you. Anything further? Counsel, anything further?
No.
I make a finding of violation on charge 1, significant adverse information, based on the evidence provided, and particularly the 3 guilty disciplinary reports received in October 2024 after Mr. Nieves' board review. That concludes the fact-finding portion of this hearing. Counsel, should Mr. Nieves be re-paroled, where does he plan to live, and what are his employment options?
He does have a sponsor lined up with his uncle. It's Mr. Avelino Vega Franco. He lives at 286 Birch Street in New Haven. He has been a support system for him, and I believe was sponsored previously. He is also looking to go back to WB Mason, which is in New Haven as well. I believe it's located on State Street. I don't have a number for that at the time. I don't know if Mr. Nieves remembers.
Not off the top of my head, but I am in contact with the boss, the third shift boss.
Okay. So yeah, he does have employment opportunities lined up as well as sponsor and place to stay.
Can you spell his uncle's name for me?
I'm sorry.
Can you spell his uncle's name?
Go ahead, Mr. Nieves.
AVELINO, and the middle name is VEGA, and then the last name is Franco, FRANCO.
And it's 286 Birch, BIRCH Street.
Oh no, there is a BURR, like Birch Street.
Oh, Burr. My apologies.
Okay.
No,
And his phone number.
Attorney Canning should have. I don't have it top of my head.
It's 203.
Yep.
654 5161.
Thank you. It should be noted that Mr. Nieves' special parole re-parole date is on December 9th, 2024, and his special parole end of sentence is on 12/21/2030. I will now turn the hearing over to the panel. After.
Thank you. All right, Mr. Nieves, did you know that what you were doing was wrong?
Yes, ma'am.
Okay, so you knew you weren't supposed to be contacting your victim?
Well, yeah, through DOC policy, of course. That was a confusion, and that's why I brought this piece of paper from the conditional discharge, because it states right here a conditional discharge begins the day it is ordered unless you are in prison, in which case it begins on the day that you are released from imprisonment. So I know that's I was wrong inside of DOC, and I apologize for that. And and I signed the tickets right away. But as a conditional discharge, I thought it started when I left out in the community.
Okay, so what about parole? Do you recall signing off on your special parole conditions?
Yes, of course. Yeah.
Okay, of course. So of course you would know that you were not to have contact with that person.
Yeah, per the parole officer's permission.
So wait, did you have permission from your parole officer to have contact with her?
No, because I've been incarcerated since February
Right.
9th.
So your special parole is still running while you're incarcerated. You're aware of that.
Yeah.
So the conditions still apply.
Apologize.
I don't want you to apologize. I want you to stop contacting that victim. Why? Now, I'm assuming the claim through these text messages I have no idea what year they're from. I have no idea that they're real text messages from this person. I don't see any way to really prove that unless you contacted the provider, the phone provider. But anyhow, if the claim here is that she wanted you to contact her, why would she say that she's afraid of you?
And
She doesn't want you to contact her.
That's why I'm confused about that. That's why, because I've never threatened her. Listen, these are the, ma'am, honestly, these are the two people that I love the most in this world.
You've never threatened her? You have 3 violations with the same victim.
No,
One of them is
that's
for
not correct.
threatening.
No, I have one violation protective order that I just got this year. That's my
Parole violations.
No. This is my first violation of protective order ever in my whole life.
You're not hearing me. I'm not talking
sorry.
about violation of protective orders. I'm talking about parole violations.
Oh, no, you're correct. Yeah. Sorry. Yeah. No, you're right.
I mean, you have threatened her. You've assaulted her. We have all of your records here. So if somebody tells you not to contact her, you don't contact her. I don't understand what the problem is. And you're breaking the DOC rules to do so. Did you know that you could lose your parole date?
To be honest with you, no, I didn't.
Right. I think that's a misconception here. People think they get a new parole date, they can do whatever they want, but we still have to follow rules here. And we take contact with victims of domestic violence very seriously. There's a reason the court orders you not to have contact.
May I please say, excuse me?
Sure. Go ahead.
This is the person that, I've been trying to keep my family together. This is my only son, this is her only son. And she's written a letter to Ruth Nieves before. She came to court saying she didn't want me in jail. So this is not, I'm being perceived as like a bad person, a bad father, and a monster when I'm not. Like I've been trying to keep my family together.
Who told you were a bad father?
No, I'm just saying, just the paragraph that she sent in, I just felt it was unfair to describe me. Like, she didn't want to have contact with me when that's not the truth. She's written Ruth Nieves. She's written a letter to the board of pardon and paroles on my behalf, stating that we're trying to keep our family together. Yeah, something happened between us, and things been bumpy on the road. She had postpartum. I didn't know how to deal with that. This is our first children. I was working all day. She was staying at home with our son all day. A lot of things were happening all at once that new things that I didn't know how to deal with. And that's why I say that, I was trying to keep my family together. That's why for her to say that she's in safety, afraid of me or my son. First of all, I've never, ever hurt my son. I'm trying to be the best father ever. And still to this day, I would do anything for her. So for her to say that is honestly, I can't believe she's saying that. Because I'm a person, listen, I gave my last $1,200. I'm in here struggling because I gave her my last $1,200. My uncle gave $100 on top of that. $1,300, that's the only time she brought my son to my uncle's house in 10 months. So it's, I just don't understand how she's saying it. And I understand people's feelings change, and I understand that. Trust me. She's never reached out to my uncle. She's never stated, oh, Kenny, don't reach out to me. She sent those text messages to my uncle, and then I could have updates on my son, and that's all I was doing. And it was
all right, so let's put all of what she says, does, whatever aside, because I don't really care. That's not my job to decipher. What I care about is that you have a protective order from a court of law that you violated. You have conditions from this parole board that you violated, and you have rules of Department of Correction that you violated. regardless of what she says, a victim in the state of Connecticut does not have to say, I need protection from him, I'm fearful. If other people feel that it's a dangerous situation, judges, parole boards, we can impose these conditions, regardless of what a victim says. We don't need her to tell us anything, to be honest. There's a protective order in place. You violated it. That's all I need to know. And this idea that you're going to try to keep this family together, it's not working. It's time for you to accept that it's over and walk away.
No, I understand that. Now I'm talking about, I was telling you before that, before, you know,
No, but
before
this has gone on 2 years too long, maybe even longer. It's been over. Ms. Berry.
No questions.
Ms. Palmieri.
No questions.
Yeah, I mean, it's a tough situation.
It is. I mean, Mr. Nieves, I think we can appreciate that he wants to be a good father,
Right.
have contact with his son. You need the proper channels.
Right.
To be
So let's talk about that.
Right.
How are you going to be a good dad in the future?
by staying out of jail and, you know, going to the courthouse and following the rules by, you know, by accepting what the parole officer states, because still I can get out right now, go get a job, and the parole officer can say, you know what, you can't have contact right now, and I have to accept that until the parole officer is ready to, you know, when they think that I'm ready. Because
When is the last time you saw your son?
The last time I seen my son was a long time ago. Over a year ago. It's been a long time.
Okay, so at that point, how did you see your son?
When I was at the halfway house, because they came to go bring me my stuff, and my son was with them.
Who?
My uncle.
Your uncle brought your son to visit you at the halfway house?
Yeah, well, not visit, but you know, when they brought my stuff, you get a drop off. He was with them.
So you haven't had any visitation with your son?
No, ma'am, and I've been trying to fight for that. I contacted DCF. DCF told me they couldn't get involved because we didn't have a DCF case. And then the parole officer, you know, listen, there's 70 people in the halfway house, and I totally understand, you know, they're full. These people, you know, and I understand that, but I've been asking for help, and New Haven don't have no single father programs to help me. Like, there's no programs in approach to not help me.
Courts. You have to file a motion for visitation with the courts.
I'm a new father. I didn't.
You need to go to, Mr. Nieves, you need to go to 235 Church Street. You need to go to the family court. You need to file a motion for visitation, and you need the court to set parameters for visitation. Because right now, you're the one, everything looks like you are the one that's in violation, and you are.
Yeah.
You know, there's harassment, looks like, in your prior violations. So if you want to be a good father, you'll take the proper channels. You'll go to family court. You'll get, DCF isn't going to help you, and parole's not going to be able to help with that. You have a protective order that says you can have no contact. So you need an outline of how that's going to happen and who's going to facilitate the third party contact. And that doesn't mean you drive in the driveway, pick up, you know, there is a third person that's away from the victim.
Right. And he doesn't have to wait until he gets out of prison. He can do the paperwork now to start the visitation process, to get the ball rolling, to get yourself in a better position. But you cannot continue to try to contact this victim through anyone right now with this protective order in place.
Do you understand why there's a protective order?
You said what, ma'am?
Do you understand why there was a protective order imposed?
Of course.
Why?
Because I was in violation of protective order.
Why was there a protective order imposed against you?
Because the state believed that, you know, that there was an issue, so they want to make
Why
sure
did they
that.
believe that, sir? Did you take a domestic violence program
Yeah, I did.
while you were incarcerated?
I just finished it in August, and I learned a lot from that. That's why, you know, I think a little differently from that, because
So
I
you
learned
never
a lot.
did it before then? You never did it before when you were in the community?
No, ma'am. Oh, no,
You
I
never
was
had
in it. I was in it, but I never finished it because I came back on a
So-
violation.
Tell me why the court believed that you were a danger to your victim.
Because they seen the police report, and they seen that there was a problem. The prosecutor and the judge.
What's in the
Because
police
I was
report?
in the wrong, huh?
What's in the police report?
Well, the last police report, we were arguing over text messages and we're, bumping heads about financial issues. And then that's how she called the cops on me, because we were arguing and she thought that I was gonna go over the house.
Did you ever assault her?
The first time, yes, ma'am. We got into a fight.
I don't know that you've learned much from the domestic violence program, but you'll take it again and pay attention, pay close attention. Because in order for you to move forward and fix yourself, you have to accept full responsibility for the things you've done, and you're still having difficulty doing that. Okay? So right now you're on what? Loss of rec, it looks like, and restriction from your tablet?
Yeah, until 12/17.
Yeah, all right. Attorney Canning, is there anything else you wanted to add before we deliberate?
I just want to give a quick thing. Mr. Nieves is 38 years old. He's been in since February. Like he just alluded to, he has taken the domestic violence program, finished that in August. He was signed up for the fatherhood program. However, that was canceled in September for whatever reason. So he is trying to make strides to, be a good father, learn from this situation. He has taken responsibility by pleading out to the disciplinary reports, has not had contact with the victim or their child since this occurred. I have explained to him ad nauseum that he is the one that has everything to lose in this situation because of that protective order. Even if she does reach out to him, he should, stay away, stay clear, have a third party facilitate that. And he is open to that, whether it be through the state, a third party, DCF, what have you. He understands now, unfortunately, that he can't have that contact because there will be further consequences. And I do believe that he is remorseful and that he will ultimately learn from this moving forward.
Okay. Mr. Nieves, it's very apparent from your file that you have some issues with self-control. You've had a lot of problems with adhering to your parole conditions, and you really need to get it together. Take advantage of whatever program you can and really listen to people and try harder to follow the rules. They're here for a reason. We don't want to see you in prison. You're a young guy. We have other things to do. And we know that you want to be a good father. We hear that clearly. Go ahead.
The paperwork should be up there as well, but I also worked at Young New Haven as a supervisor for 3 years, a health cancer patient. I ran a COVID site. I got Employee of the Year for the East Coast. But, I was home for 3 years, and I know I've been catching little violations. I've been having family issues, but I'm also a person
What
that
is a
changed my
little
life.
violation? Tell me what a little violation is.
Well, not little violations. I've had violations, for the past 3 years, one a year. But I just feel
One
like
a year? I mean, that's unacceptable.
no,
You don't
I,
belong in prison. You're a father. You don't belong in prison.
It's also minimization. You're minimizing your actions, sir. You have a lot of work to do.
I just feel like all the things that I worked hard for are being overlooked.
5 violations. No, they're not being overlooked. That's not why we're here. We're here to talk about how we're going to keep you out of here, out of prison. We don't want you to keep coming back. And, you can do all the good things in the world, but when you do something bad, it kind of does cancel it out, right? You're in prison. That's the bottom line. All right. So give us a few minutes to discuss your case and we'll come back to you with our decision.
All right,
This
thank you for listening.
this is a tough one. Honestly, Mr. Nieves is struggling and he needs a lot of work. He really does. He's got until December of 2030. I don't think he realized he could lose his parole altogether and sit there until December 2030. So hopefully the message gets out, because this is crazy. We give people parole and they think they can violate all the rules.
I think that we tell them too that, don't get any tickets. They just don't, I guess.
But these are serious tickets. Contacting a domestic violence victim is a serious violation of a rule and the law, man. So, obviously we're not going to keep them until December of 2030. There's no point in that. I am happy to hear that he's taken programs, because in the past we've had difficulty with offenders on special parole getting into programs. So I'm glad he's doing that, but he needs more programming in the community. So what are our thoughts here?
I have him, his parole rescinded, and I have him serving a 1-year sanction. They gave him an unconditional discharge for violating the protective order in April. And, that was they actually could have given him a new sentence. But they gave him a slap on the wrist for that. And he still continued to reach out to the victim even after that. So for me, it's it sounds like complete disregard, although I understand his rationale. I feel like he's been given a number of opportunities to get this right, and he's still struggling. So, again, my vote will be to rescind and a 1-year sanction.
Okay, Ms. Palmieri?
So I agree that these are incredibly serious sanctions. The victim is afraid, and that we have to take very seriously. I was not at 1 year. I was actually at 6 months, which might allow him to do a little bit more programming in the facility as well. I did want to check. He does have mental health counseling on his conditions already, which I think is, in addition to domestic violence, an important piece for Mr. Nieves, because he does have some issues with self-control, and through the domestic violence and mental health, I think that could be beneficial.
It's a 1. It's a 1. Wow. All right.
Yeah.
Why don't we split the difference?
9 months.
9 months?
9 months. I mean, that's better than what I was thinking. So for him, anything is a gift. Yeah.
I mean, he's got a great job. He's had great jobs.
Yeah.
He's able to live and
Right.
he's able to work in the community and be productive.
Yeah.
I don't think that we're not acknowledging that. It's just, he needs to understand that the law is the law, and none of us are, we can't avoid the law. But if we break the law, any of us, there's consequences for our actions. So 9 months.
Are we clear on what no contact means? You can't have 3-way calls, no letters, no send something to your uncle to pass along to her, just 0. I hope you understand now.
Don't worry about it. I'll never have contact with this person ever again in my life. Trust me. I'm all right. I'm all right with that. I'm gonna go straight to the court and deal with that. See my son that. But you guys, listen. Once I leave here, you guys will never see me again. I promise you.
I hope not. I hope not. This was a difficult file to even follow. It's just such a mess. All right. So I have a September 9th, 2025. Wow.
Yep.
All right. And there's a whole lot of conditions.
Yep.
So we'll go over them. Okay, in the matter of Kenny Nieves, inmate number 339506, I'll make a motion to rescind special parole and re-parole with a 9-month sanction on September 9th, 2025, with the following conditions. No consumption of alcoholic beverages. Domestic violence program, again, in the community. Do it again. No contact with your victim, initials NH, and no contact with LN without your parole officer's permission. We want you to get it all straightened out the right way. Visitation, okay? No contact with co-defendants George Gomez, Salo Flores, Tashawn McDade, Donald Holder. No contact with co-defendant Jasmina Acuna without your parole officer's permission. Why is that without PO's permission? I wonder. Oh, well, all right. Halfway house placement, and I understand you're going to give your uncle as a sponsor, but just in case that doesn't pan out for whatever reason, we don't want to hold up your release. Halfway house placement if it's needed, and a mental health evaluation and treatment if it's deemed necessary. Did I miss anything? Is there anything else?
Nope.
No? All right, is there a second motion?
Second.
All in favor?
Aye.
Aye. Do you have any questions, sir?
No, ma'am.
Or Attorney Canning? Anything unclear?
Nope.
All right. We wish you the best, sir.
All right. Thank
Keep
you.
working.
All right. Thanks, Mr. Cannon.
This concludes the rescission for Kenny Nieves, 39506.